Joining us tonight to discuss is Erin Carr, Assistant Professor of Law at Seattle University. Erin, thanks for being with us tonight.
Good evening, Joyce.
Well, first, from a constitutional standpoint, does what we are watching in Minnesota meet the legal threshold for using the Insurrection Act?
Well, historical precedent does not support the use of the Insurrection Act in response to anti-ICE protests in Minnesota. By way of context, the Insurrection Act is a rarely used exception to the foundational democratic tenet codified in the Posse Comitatus Act that limits military involvement in civilian affairs. Because it is a long-standing, well-respected principle of American governance that precedents are prohibited from using the federal military for domestic law enforcement purposes, Congress only intended the Insurrection Act to be used as a last resort by the president in extreme emergencies. As a result, the Insurrection Act has only been invoked 30 times in our nation's history, in exceedingly limited circumstances that do not apply to the current events in Minnesota.
So then how much power does the president have under this act compared with like governors and mayors, and where do the courts then draw the line between them?
The Insurrection Act is one of the president's broadest and most potent emergency powers. And for that reason, it's been very judiciously used by past precedents. Precisely because the Insurrection Act has rarely been used and therefore infrequently litigated, there is very limited legal precedent to guide potential future challenges should President Trump invoke the Insurrection Act to deploy the military in U.S. cities. The Insurrection Act, while not a blank check for presidential powers, does afford the president fairly broad deference, and in part because the law is vaguely worded and has rarely been interpreted or applied by federal courts. But even while recognizing the broad authority of the president under the Insurrection Act, the limited legal and historical precedent nonetheless suggests that there are a very narrow set of circumstances in which using the act is appropriate, and that the use of the Insurrection Act in Minnesota would arguably be an abuse of those broad presidential powers that would be inconsistent with both the legislative intent of the law and also fundamental constitutional rights and principles.
Could a similar clash over immigration policy and local resistance happen here? And what signs would you be watching for in case of that?
Legally and politically, there are reasons for the president to reconsider his stance towards the Insurrection Act. However, if the president were to follow through with his threat to invoke the Insurrection Act, I suspect that he would first test the Supreme Court's tolerance for his unprecedented use of presidential powers in Minnesota before potentially expanding his tactics to other cities.
And if he does do it, what do you think the precedent would be moving forward?
I think it would be disastrous to civil rights, and I think it would mark a dramatic change in the way that our democracy and our rule of law operates in this country, and certainly not for the positive or the best.
Erin Carr from Seattle University, we always appreciate your insight, your legal insight into all of this for us. Thank you.
Thank you, Joyce.